Glad you're here. I'm going to generally follow the page-by-page flip as you have, but I was doing some sort of mock presentations before I came here. It will not look like I practiced, though, trust me. And some of them I might do in a little bit different order because it makes sense that way. But after a potential investment has been identified, usually one or more apartments, and underwriting has taken place to make sure that this is something that we want to pursue based on what we're paying for it and what returns we think we can receive from it over time. The next step is a LOI is submitted, and that's when the parties on both sides, as you probably know, and I'm going to be repeating things that you probably have common knowledge of, but an LOI is put together and it sets forth the basic structure of the transaction. And those documents are not usually enforceable at all, but it's something that the attorneys work off of. And it's sometimes frustrating because at least when I'm not doing this, where the attorneys will want to vary from it, usually not in purchase price. And the claim, what you say is, well, I thought we already agreed to all this stuff. But basically, the LOI doesn't mean a whole lot other than just being a guidepost for how I'm going to draft the contract. So usually what happens, I get a letter of intent and then take the basic provisions and put it into one of several different types of PSA templates that we have here, depending on whether we're buying or we're selling. And I'm sort of going to go through this as though we're on the buy side. When you're on the buy side, you are much more concerned about, you're going to have a thicker document if you're on the buy side than if you're on the sell side, because you have all these different provisions that, where the seller is, telling you things about the condition of the property that you have assumed to be the fact for purposes of coming up with a purchase price. And the very first part, literally by section of the PSAs, is an identification of the property. And of course, that's going to include a description of the apartment complex, the land itself, but it goes on to describe all sorts of other property that are included within the, that are part of the real estate aspect. And that includes personal property, things that are located in the office, inventory, golf cart sometimes where they drive people, residents around. And it also includes intangible rights such as the right to keep the name of the apartment complex in place after we close. Every so often there's like a trademarked name, usually for a larger owner of real property and projects, and they sometimes don't want you to use that name because they associate it with their other projects. So purchase prices, designated, and then a portion of the purchase price, the earnest money, is usually paid up front and deposited with the title company that holds it in escrow until closing, or if there should be an event that requires the return of the earnest money to one of the parties. But the earnest money is, if things work out, the earnest money is applied to the purchase price, and the balance of that purchase price is paid at closing. And that's where everything works out perfectly. And you have to draft these documents, though, with the assumption that things may not work out perfectly. Most things more or less work out with back and forth sometimes. Sort of the most probably time-consuming and important processes of acquiring property is the due diligence period. And typically it can vary by a few days depending on the project. But for our multifamily deals, it's usually a 30-day period where either we or our agents go onto the property and physically inspect it. They walk the units. They look for signs of waste and failure to keep the property repaired and in good condition. And it will usually include not only a team from our we sometimes just pick people who have experience in this, but RREAF Residential, I believe, and David, you correct me, is typically the organization here that puts together these teams that go out there. And so they look at the physical aspects of it, and then they also review perhaps the most important thing for all of what we do, and that's the leases, because the leases generate the revenue, and they are what create the return that we're trying to achieve, both while we're holding it and when we flip the property. And our general strategy, as you probably already know, is you buy it at one price, you try to add value to it, which may be just making repairs, et cetera, and then you sell it, usually within 3 to 5 years, sometimes cobbled with other properties, and you hopefully make money, and hopefully as much money as you believe that you should have made. But anyway, so that's the due diligence period. And aside from the sort of in-house management inspection team, you usually will have an environmental firm that does what's called a phase 1 environmental site assessment. It's pretty much a superficial review of the property, but looking for signs of any possible release or storage of hazardous materials on the project, which can give rise, once you buy the property, to you may have to do remediation efforts that are costly. And if they see something that makes them think that there might be a problem, they usually recommend what's called a phase 2 environmental site assessment, and that's where you may do soil bearings down to actually test the soil, et cetera. That does not happen very often, but it's one of the things that we do. Also during the due diligence period, there's what we call a title and survey review and objection period. They roughly sort of approximate the same length of time, but it can go over or be a little less, just how the PSA is negotiated. And what happens is, shortly after we enter into a contract, this is with us being the buyer, the designated title company will provide what's called a title commitment. And that title commitment basically is what they're committing to issue a policy of title insurance at closing, ensuring title to the property, subject only to a list of what we call exception documents. And almost all of those exception documents are ones that have been filed of record, and they indicate the title history of the property. When we're dealing with multifamily projects that have been up and running for some time, the likelihood that there's like a title problem is much less than if you're buying raw land and are going to then develop it into something, because the approvals to do what you do, that is operate an apartment, have already been put in place. But there are exceptions to that. And if you find a title problem, you make a so-called objection to title to the seller, and then the seller has a certain amount of time to either say, hey, I'm going to fix this, or I'm not. And if they aren't going to do it, you typically have the right to terminate the contract and get your earnest money back, and the parties go away. Similarly, with the physical inspections, there's not really an objection period to any of the things that you might find there, but it again is 30 days. It's a 30-day period, and you can terminate at any time for any reason, typically. And so once you've already gotten to the closing process, and let's say you find $120,000 or $500,000 of necessary repairs, you go back to the seller and say, hey, we're not moving forward unless you lower your purchase price by this amount, or you fix the problem before we close. That happens every so often. Most of the time, it does not. But that's the leverage you have. Is say, I don't mean it the way it sounds, but you will have wasted a bunch of time with us. You will not have the ability to work with other buyers during this period, so you're more motivated to make those concessions. So after 30 days, the earnest money goes hard, meaning that except for certain instances, you as the buyer do not get the money back. But if closing occurs as planned, it will be applied to the purchase price, as I indicated earlier. When sellers, sophisticated sellers enter into contracts, especially ones for considerable amount of money, they want to have you accept the property in as is, whereas condition, meaning we're not doing anything, we're making no promises. You had a chance to go to diligence the property in the due diligence period. You had the chance to look at, review title, and so get yourself comfortable during that period. But if you don't object or terminate, it's all yours. You take it, warts and all. Of course, buyers don't agree to that in so many terms. You usually have what are called representations and warranties, and they're on both sides. But the most important ones are the ones that the seller gives you. They basically are kind of exceptions to the as-is, where-is condition of the property. And so these will typically say, like, the seller represents and warrants that there is no environmental contamination on the property. You represent and warrant that the lease roll, which tells you the status of the leases and the parties that are there, and the amounts and the security deposits are true and correct in all material respects. They make reps and warranties that there's no litigation on the property that would impact the ownership of the property post-closing. They make reps as to, okay, these documents, we usually call these service contracts, are the only service contracts that impact the property. And service contracts typically include things like communication and cable TV agreements, and those oftentimes run past closing and you can't get rid of them. And little things that are really not a lot of consequence, like landscaping, garbage collection. They sometimes sub out their maintenance and repair obligations, et cetera. And during the inspection period, you have those contracts to look at and decide whether or not you want to be subject to these post-closing. And typically you object to those, but again, it's sort of like the seller will either tell you, we'll terminate these by closing, or sorry, either we can't terminate or you can't even take assignment of them. And so the parties come to an agreement as to what's going to happen. There's usually never a service contract that is written such that it would kill the deal at all. It just may affect economics slightly. And one reason that it's very important to get all of the service contracts, and this comes from an instance that occurred, is they may indicate that not only are they there and will apply to you typically, but they may indicate problems with the property that if you didn't have that service contract, you wouldn't know. And like a real world example was, there was a building that had been destroyed by fire, I believe, on one project we were working on. And they had told us that they were going to repair the building prior to closing. And it was frankly a bust in the document on my part that I didn't include their obligation to repair it. It was sort of a foregone conclusion they were doing it. But we got to this point where they're like, we're not doing anything. It's yours. We didn't say we were. But what they failed to do is provide us a copy of their existing construction contract for the repair of it. And the reason why it was a big deal is because this building contained asbestos and needed asbestos remediation, which doubles or triples the cost of repair. They didn't provide the contract, and so they were in default for doing it. And if we would have had that contract, we would have known that it required asbestos remediation. So the lesson is, don't make a mistake like that, you're forgetting to include the obligation to repair, and then number two, the importance of having all of the service contracts to look at. So that takes us to the closing process and what deliveries you have to provide for closing. And so both parties on the date that's specified for closing, usually 30 plus days after the due diligence period ends, they agree that we're going to provide all these closing documents, deeds, assignments, et cetera. We're going to give you the leases, the keys, everything. It's yours. Take it. And so there's a number of documentation processes that go along then. And if everything goes well, the title company will issue you a title policy that's subject only to the permitted exceptions that you have signed off on or waived your objection to. At the end of the day, the funding's provided and the buyer then takes title to it. And so that's sort of the, okay, everything went right kind of scenario. There are provisions in the contract that deal with defaults and breaches of the terms of the contract. And those oftentimes are where a representation is made by the seller and it proves to be untrue. And if you determine that rep is untrue prior to closing, the typical remedy is, say, you can terminate and get your money back, and maybe you'll get some costs that you incurred, due diligence costs, et cetera, along the way. The other option is typically you waive it and you proceed to closing. It's your choice. But it's like, if you move forward, you cannot complain about this breach at any time. Once you've closed the property, most representation and warranty provisions provide for a survival period, meaning these will last out 6 to 9 months. And if you find, and you didn't know it before, a breach of a representation or warranty after closing, typically you have the right to pursue the seller for the damages that you incurred as a result of that. Sort of a related provision is limitation of liability. And so you agree to all this stuff up front. You sort of contemplate what if things don't go right, here's what happens. And that will usually be about 1 to maybe 2% of the purchase price that you can pursue the seller on if there is a breach of a rep and warranty where you incur damages up to that ceiling. One thing I didn't mention, and I kind of should have done it in a better order, is the parties typically have covenants that they must, and that just means obligations that they must perform during the closing process. And they're mostly ones that are binding, or ones that the seller is charged with performing. And those typically mean you're not going to make any material changes to any of the buildings. You're going to use good faith efforts to keep the occupancy level of the apartments where they need to be, and typically they need to be close to 90% for a lot of the financing types that we use here. Others, or you won't enter into leases or agreements on terms that we haven't agreed to in writing, so that you don't get to closing and then there's a whole different set of lease terms and economics that you weren't able to evaluate during your due diligence period. So I would say that that I may be going too fast for this, but that was sort of the scope of my presentation today that I came up with. So if you guys have any questions or comments, feel free to ask them. David will always have questions and comments, so we'll just see what he comes up with. Yes?
Daren, and maybe you went over this before I stepped in, but as far as closing costs are concerned,
right?
Closing costs, can
yeah.
you kind of identify typically which party, buyer, seller, is responsible for which,
sure.
and which party is involved, which party typically selects the title company?
It depends deal by deal, but the way we do things, and it also depends state by state, because we do things all over the United States, mostly concentrated on the East Coast and Gulf Coast, around to Texas and then up to Arkansas, and in some instances. We have one project that's in Baltimore, of all places. But it depends from state to state. In Texas, the seller customarily pays for title insurance. And because they're paying for it, then they select the title company that they choose. And we have a really good relationship with Commonwealth Title here. We send them with, millions of dollars worth of business, and they are extremely responsive and work with us and solve problems that sort of a title company we didn't work with a lot would. At least that's my impression. So I'd say as a general rule, the party who's paying for the title insurance can make a good case that they should be the party that picks the title company. And when that comes up where we're paying and they want to choose their own title company, I'm saying, no, we're choosing it, but you can pay for the title insurance and you can choose whoever you want. And usually that solves the problem. They just go with your title company. Now, in states other than Texas, there can be significant charges that they're sort of like taxes or fees. They're for states to line their pockets that accrue when you transfer property. And you'll have things that are called like deed or stamp taxes, and you have, and this is for the financing, like mortgage taxes or intangible taxes that are related to that. And they're just stupid, but they're basically just a way for the states and perhaps like the counties or municipalities to make extra money that they shouldn't make. I'm being political here. But those are allocated between the buyer and seller differently. It depends. And so we'll either specify who's paying for it in the LOI up front, or we will default to what's customary in the state in which the closing in this property occurs. But it's all over the place. And they can be significant. And they're usually some, dollar per $1,000 of the sales price or the mortgage amount of the property. That's how you determine it. But that's a kind of a frustrating aspect of it, because a lot of people have different interpretations of what the customary practice is in the state that we're in. So you have to kind of figure that out independently, and then you negotiate it. And then another thing that happens, and this applies to everything in the PSA, if we really want the property to buy it, or we really want to sell it, and there can be different levels of anxiousness on our end, you're more willing to negotiate those prices or allocate those costs perhaps to a party that isn't customarily allocated those costs per whatever the state custom is. In Texas, thankfully, we do have more expensive title insurance, but there are no costs or fees associated with the transfer of property or financing it, other than you have incidental recording costs, which is literally you pay $2.50 a page, and they can be hundreds, maybe low thousands, but they're not really the equivalent to the amounts you would spend for transfers in other states.
Is there a capped amount by Texas for title insurance?
Well, there's not a
Percentage of,
there is, but it also depends on how large the amount they insure is. Once you pay the highest at first, and then once you get up to a certain level, it de-escalates so that you pay less and less as it goes up. But title insurance in Texas is strictly promulgated and a matter of law. So you can't negotiate it. Like, hey, I'm giving you a lot of business. Can you knock off 10% of the fee? They can't do that. Other states, you can negotiate them. And
vice versa, they can't charge you more than what any other.
That's correct. That's correct. But compared to other states, are making more off title insurance premiums than the other states do.
And typically, who best prepares? Is it the title company that best prepares a closing checklist for both parties, or?
The way it typically works is the title company, and we as a party to the transaction do our own internal one, but they basically will take the contract and they provide to us like a critical dates list, and it's just something we put into our calendars and remember and make sure it's a few days before whatever the action item is, so that we know that something's coming up. And that's, a lot of times you have, not only you deposit the earnest money up front, but oftentimes you'll have an additional earnest money that you have to deposit once the inspection period has ended. It's sort of like just getting the buyer more invested into this property, so they need to really think long and hard about any excuses they might come up with to closing, because they're going to lose all that money.
Typically, the lender will drive the full-blown checklist of everything that needs to be provided to the title company.
That's right. That's right. The reason why reliance on the lender cannot be absolute is we oftentimes, like maybe every time, do not know for sure who's going to be financing the property, and you'll be perhaps almost out of the inspection period by the time that financing is secured, and the lender will give you this, usually longer than you want them to be, checklist of items they want to see. And it's not just due diligence items, but your authority to enter into these transactions. They want to see, in some cases, contracts, if there's going to be additional work that we do on the project, which happens not that frequently, but it happens a good amount, and a bunch of other things. So we and it's something we need to do a better job of, but we prepare our own internal checklist, and that gets started not too much later than once we sign the contract up. And the checklist more or less includes items that's pulled from the contract itself, and it will also include things that are external to it, like this is what we need to do during due diligence. Do we have the ESA done? Do we have an engineer go to the property and look at the structural integrity of the buildings, et cetera? And that's another group that will go out and look at the property in addition to us and the environmental. And have we made title objections? Have we gotten back from the seller an obligation to cure those? And the list goes on. And we have a very good checklist, but oftentimes the biggest issues that we're dealing with are solving the lender's needs, because if you don't get them happy, then they're not going to provide the loan. And so we oftentimes will work off of their checklist because it's usually as comprehensive, if not more so, than our own. And the importance of providing all the information that are on that checklist is essential for us closing the loan.
So post LOI, would you say it takes around 90 days to close on a property typically, or a little longer?
I would say that's right. We call it 30-30-30. That often comes up, and what that means is 30-day due diligence title review period. 30 days after that period is ended for when the closing is to occur, and we typically build into all of our contracts, sometimes it varies a little, the right to extend the contract for an additional 30 days, and that's to line up investments, it's to solve title problems, it's to get our lenders comfortable. We want more due diligence time, and sometimes we negotiate that depending on what we find on the property. But like 30-30-30 is like the standard timing periods of them.
And that's once you sign a PSA. In terms of LOI, it could take much longer than that.
Right, so it can take a month to get a contract negotiated. I mean, there's a lot of pressure on me to get these things signed up sooner rather than later. And a big function of that is how heavily negotiated the contract is based on the other side's attorney's comments to the document. And it can just, it happens a lot where you've got some overzealous attorney on the other side that just goes crazy, and then you have to weed through it and try to meet them halfway, and that's when it can turn into multiple weeks. But we signed them up. I mean, we had 3 deals that we needed to sign up for sort of a complex arrangement, and we got them signed up in a day, But it usually takes longer than that to get it done. Yes?
I've got 3 questions, so I'll hammer around one at a time. So with the lender, do you guys include them in the PSA, and how do you meet their qualifications within that document?
Most of the time, there is no reference in the document to a lender at all. Your obligation as buyer is to show up with cash at closing. Cash would come from the loan and equity investments. Sometimes there's a financing contingency. That's rare. In fact, usually the purchase and sale agreements will have language that says there is no contingency for obtaining financing to close this loan. You're on your own, baby. I mean, that's typical. Now, I would say maybe 10% of our deals where we're either buying or selling may have an assumption component, and that's where the buyer is taking an assumption of the existing loan and then typically paying the difference between that and the purchase price in cash. And so in those instances, yes, the lender's specifically named. You have all these things that must happen in order on both parties' sides to obtain that, the consent to the assumption, and then certain outs if you're not able to get the lender to allow you to take assignment of the financing.
And if we were looking at that situation where we have an assumption, where would that show up in the PSA itself? Where's that going to show up in the PSA?
I need to look at this to see the structure of it, but it oftentimes will be it'll be included either embedded within the due diligence, the inspection period section, or there's conditions precedent to closing, meaning if these aren't satisfied, there's one set that applies to the buyer and another part that applies to the seller, and you performed all your obligations to obtain that assumption, then you can go away and get your earnest money back. I mean, we just signed up a deal where HUD is the lender, and those take notoriously a long time to get done. So they have 190 days under this particular contract to get the approval of the assumption. And we likewise buy properties that are subject to existing loans. Typically they're HUD, these are what we call agency loans, HUD, Fannie Mae, Freddie Mac. I can't think of any instance, I'm sure there are some, where it was just a conventional lender that we are taking an assumption of as buyer. No. Staring into the void.
Yeah.
Daren,
Yes?
is there, can I ask a question? This is Tabitha.
Of course.
Is there states that are easier to work with than others, and which states are those?
You know, the real factor is the negotiation of the document between the seller and buyer. That is the biggest time-consuming and frustrating aspect of getting it taken care of. I would say when we're doing things in other states, they may be a little more complicated because we have to conform our documents, not usually too much, to be consistent with that state's requirements. And those things oftentimes will just be like the form of the deed. It has to look a certain way for that state, just spacing and contents of it. There's oftentimes a reporting obligation to a government agency or subdivision of that state as to the taxes that become due upon the transfer. But I don't really think of a state that, I mean, Louisiana, come on, it's going to be harder no matter what. I don't know why I said that, but it usually is. And here's the other thing. Most of the states where we're acquiring these properties are Gulf Coast states, or basically from South Carolina down to Texas. And those states are all kind of old school. And they will sometimes not have a title company that actually prepares the title commitment and the documents necessary for the issuance of a title policy, but it'll be a lawyer who's doing all that. And oftentimes that slows things down. It may be more costly. It's a bit more antiquated. And so, that can be an issue. We've grown so much that there's really no state in that trajectory that we haven't closed multiple properties in. And so we're already familiar with the process. Also, assumptions of, like I think I sort of mentioned, of existing debt add a completely new wrinkle to all the stuff that you have to do and provide and time periods that have to take place before you can close. But I'd say the biggest factor in timing is just the attorney and the principal on the other side and how willing they are to, meet you halfway. And you get, and this happens, and it's frustrating from my standpoint, everyone's, where you'll get a contract and you have some grumpy seller that's like, you take it this way or we're not doing the deal. That's how they talk, actually. But and we've had to do that. We go through and say, okay, worst case scenario, here are our risk factors, but the deal is so good that we usually can find a way of doing it. Sometimes we say, forget it. This is unreal. You guys don't really want to sell your property. Got it.
Is there a great, and I guess you kind of answered the question, but is there a great degree of legal variance, whether it be like PSAs, LOIs, negotiations between working with different types of sellers, whether it be like institutional or individual?
Yes, there can be dramatic ones. When you're dealing with a institutional owner, whether you're buying or selling, you're going to, and they can vary, but you're usually going to be looking at a much more complicated contract. And when I say more complicated, there's just going to be a whole lot more qualifications to things. You do things like define, like in your reps and warranties, for instance, you'll say, seller has no knowledge of this, that, or the other, and they'll go in, we do this is in all our contracts, but it says, here's what knowledge means. It means that the one person here who has a significant amount of oversight of the particular property actually currently knows something. And so you go back and forth on that. You'll have buyers, and we're one of them, they'll want all of this stuff for due diligence purposes. And a lot of it isn't customarily even prepared by us or by sellers when we're on the other side. You'll see just the representation and warranty section will just go on and on and on, and then it's up to me, depending on if I'm buying or selling, to pare that down and make it work and add my own qualifications. So the more institutional nature of a seller or buyer is going to necessarily, probably linked in the process. Now we have a three property acquisition that's underway now, where and this is when the I'm going to say grumpy old man. He may not be. I just think of him that way. Where he didn't have any review of it. He just took it, what we gave to him, and our contracts are not too imbalanced in favor of one side or the other. Certainly that contract was more in favor of us. So this is probably the wrong thing to say, but if you got a grumpy old man, it can be really easy, or he'll be so grumpy and he's not familiar with the process that he may just ask for things that are not market and are not things that are customarily provided. And hopefully he has a lawyer that you can talk to, because many times it's better for the party, the problem party, to have a lawyer, because that guy can usually provide him with some sense of what's standard and not standard. Now, of course, his lawyer is happy just to take the stance that the seller takes. He's his lawyer, he's getting paid his fees, who cares? But I'd say there is a difference between a smaller, less sophisticated seller or buyer and one that is of an institutional nature.
When you get into buyers like that, is a lot, I mean, from a legal perspective, is a lot of that negotiation because of the sophistication of the buyer, or rather the seller, or is it more a function of the sophistication of the seller's counsel?
I would say the more sophisticated they are, they're going to have, sort of like we are. We have, like acquisitions, for instance, here, and Graham, for instance, he's not a lawyer, but he knows what we will work with and what we won't. And so a lot of the things that might be considered sort of, the lawyer just wanted it this way, we kind of, as the principals here, kind of already know all those things. When they're less sophisticated and they're a zealous advocate for the seller or buyer, yeah, the attorney is going to be the one that does it. But in general, it's an attorney-driven function.
Then lastly, what's the most challenging issue you've worked on at RREAF?
I mean, I don't know how much time we have, but I'm just kidding. It's fun. Complications and challenges are fun, right? Because you learn something, and especially if you get what you want. The more challenge, sort of the things that really just kind of emotionally push my buttons are when we have situations where one of the parties is just like, we're not making any changes. You can go do whatever to yourself, and having to then make sure, and then you have the decision makers here. They really want to buy this property. It's a great deal. And so you have that pressure, and it's like, we'll agree to anything, just get it signed up. That actually has been said to me, and of course I'm concerned about it, and I know the person who says that means get it signed up, but if there's something absolutely crazy in it, I need to know about that. That's probably one of the biggest challenges. Related to everything that I'm doing, the flip side, and David's that's more his sphere, is getting all the investor amounts and requirements and idiosyncrasies in place so that we're going to have the necessary equity to put into deals. And I think we get a loan typically. We provide some equity on our part, not usually a whole lot, and then we have our investors who make up that big delta between the loan and what the purchase price is. And just depending on the deal where it's at, especially if we're dealing with something that's not an apartment, like a hotel, for instance, or just raw land, it can be, that's a big challenge. So for whatever I do on my side, David and Tabitha does a lot of that work. They have probably more and sometimes twice as much, because there's this whole, getting all the stars to align so we have the funds necessary to close. And the good thing about RREAF is, although it might, we may be, spinning in circles, we figure it out and we close it. I mean, that's one thing we don't just enter into, because this is what happens. You've got a lot of these unsophisticated or troublemakers who will go in or they don't have any ability to perform their obligations, but they'll enter into contracts with us, let's say as a seller, where we're the seller, and they can't close. There's no way that they can do it unless other things happen.
And there's people that want to flip them.
Correct.
Want to flip the PSA. Which we.
She means before closing, that you take title to it, or you enter into the contract, and then you sign your rights under the contract to somebody else. And we've done that ourselves before, but very rarely. But and that's what is frustrating, is dealing with people who aren't real, and the ones who aren't real but have all these demands. And there's competing interests here, right? Because the lawyers want to make sure everything's perfect. The business guys they want things perfect too, but what they're focusing on more than anything is the economics.